The Testator's Family Maintenance Act enables spouses and children to make a claim against a person's estate after their death. So they're able to apply to the Supreme Court, and the Supreme Court will make a decision about whether or not what was left to them under a person's will or under intestacy was adequate and proper. Now, the Supreme Court is only able to make a provision or award provision for a person out of that person's estate.
In Tasmania, assets that aren't part of an estate are joint tenancy properties or joint assets, such as a joint bank account. It would automatically pass to the survivor outside of the estate and would not form part of the estate. Assets that are owned in a trust are also not part of an estate because they are owned by the trust and not by the person. Superannuation that passes directly to a spouse or to a child or to another dependent under the superannuation legislation. If super was here and it passes directly to a dependent, it does not form part of the estate.
It's also possible for a person to have given away their assets before their death, and if the assets have been gifted or transferred and they're no longer owned by the person at their death, then they're not going to form part of the estate. This situation enables people to structure their estate in a way that reduces what's available for challenge. So a person who you might think is quite wealthy might actually have very little in their estate. And if there's little in their estate, then there's little that's available for a person who might apply to the Supreme Court for an order under the Testator's Family Maintenance Act.
So my dad's estate was emptied in the couple of months before he passed away. He was a very wealthy businessman, but we discovered once he passed and looked at his will that there was nothing there for us in terms of inheritance. So when we discovered that all of his assets had been stripped out of his estate in the couple of months before he passed away, we were really shocked, and we couldn't believe that there was no law here in Tasmania to prevent that from happening. It's caused our family huge grief and huge trauma, really, because if that law had been in place, we would have been able to apply to have a judge look at his estate and understand why this happened and make some decent provisions for two children that were very loved by a very successful businessman. But that didn't happen here because there's a gap in the law.
We don't live in a world where nuclear families are the norm. It's no longer mum and dad and two kids, and dad will give everything to mum and then mum will give everything to the two kids. We live in a world where blended families are extremely common, where second relationship and third relationships, children from previous relationships, children from a series of relationships exist. And it is becoming the norm that specific estate planning has to be conducted in order to provide for what forms part of the estate, who do they want the assets to go to. The best thing from an estate planning perspective in Tasmania is that the laws as they exist currently provide, in a sense, a large amount of freedom of testamentary disposition. And what that means is a person is able to take action to protect their assets if they wish to do so. They can take positive steps in order to prevent a child from a previous relationship making a claim, to prevent a second spouse who has only been on the scene for a few years and has independent assets of their own making a claim against the estate. Essentially, it enables them to say, if I want these assets to go to this particular person, we can set it up in a way that ensures that that happens.
Notional estate laws enable the Supreme Court to treat assets as part of an estate even though they aren't in fact part of an estate. So it enables the court to increase the pool of assets that are then available to award provision for a person who successfully establishes to the court that what they were left under a will or under an estate wasn't adequate or proper. The Tasmania Law Reform Institute has been asked to give advice to the state government about whether Tasmania should have notional estate laws. So at the moment, New South Wales is the only Australian jurisdiction that has notional estate laws, and we've been asked to give advice about whether we should have these laws applying in Tasmania.
The people can take advantage of the laws here in Tasmania for their own benefit, and without the ability for a lawyer to come in and have a look, or a judge to come in and apply some common sense to some changes to someone's will. And I just want to make sure no other families in Tasmania go through what we went through. If we lived in New South Wales, this wouldn't have been allowed to happen.
The Tasmania Law Reform Institute has published an issues paper which is available on our website, or you can contact us directly to obtain a copy. Now, the issues paper asks a range of questions, and we're asking members of the public to give us some feedback about whether or not people think that these laws should be introduced, and if they have views either way, what are the reasons for those views. So we're inviting submissions from the public. We will then consider those submissions and we'll formulate some recommendations to government about whether or not notional estate laws should be introduced in Tasmania.